Good evening, everybody. My name is Margaret Harding and I am the Acting Vice-Chancellor this evening, hosting the Vice-Chancellor's Public Lecture Series for 2012. Before I begin this evening, I would like to acknowledge and celebrate the first Australians on whose land we meet this evening and pay my respects to their elders past and present. It's my very great pleasure to warmly welcome everybody here this evening, our external guests, our ANU graduates, alumni and friends of the university, to this final lecture in the Vice-Chancellor's Public Lecture Series for 2012. This year, a number of leading ANU academics have delivered topical and engaging public lectures under the Vice-Chancellor's Public Lecture Series banner. And for those of you who may be interested, if you have not had the occasion to attend the earlier lectures in the series, they are now publicly available on the university's YouTube channel. I'm delighted this evening that Donald R. Rothwell, Professor of International Law and Assistant Head of the School at ANU College of Law, is delivering tonight's lecture. Professor Rothwell was recently named as Public Policy Fellow in recognition of his very significant contribution to public policy at this university. ANU Public Policy Fellows have been selected by the university in recognition of their contributions in areas as diverse as the environment, health, finance and economics, defence, Indigenous affairs, population and international law. Professor Rothwell is a fitting recipient of this title. From 2004 to 2006, he was Challis Professor of International Law and Director of the Sydney Centre for International and Global Law at the University of Sydney. He has co-authored or authored and edited around 16 books on important topics, of which he will elaborate further this evening in his lecture talk. He has also played a continuing and leading role in public debate on critical legal and policy issues. In this evening's lecture, he will argue that Australian governments need to develop a more consistent diplomatic and legal strategy in dealing with cases of Australians who have been detained overseas. It's my very great pleasure to invite Professor Rothwell to deliver the Vice-Chancellor's Public Policy Lecture this evening.
Acting Vice-Chancellor Margaret Harding, distinguished guests, colleagues and fellow Australians. And I say that quite intentionally given what I'm about to say. First, an apology. I'm not going to say anything at all about something that I've written in a textbook that I've edited or co-authored in recent years, but rather these remarks this evening are very much seeking to draw together commentary and analysis and thinking on issues that probably commenced one day in January 2002 when I heard about an Australian called David Hicks who was being held in Guantanamo Bay, Cuba. Over the past decade, successive Australian governments have become conscious of the expectations Australian citizens have of their government when they find themselves in peril overseas. This can range from when a citizen loses a passport, is subject to a criminal assault, is seriously injured in a motor vehicle accident, is caught up in a natural disaster or civil conflict, or is arrested and brought to trial on criminal charges. One of Australia's longest-serving foreign ministers, Alexander Downer, stated in 2005, and I quote, "I believe there is no more important role for government than protecting its citizens at home and abroad," end quote. However, Foreign Minister Downer was careful to make clear that the Australian government, and I quote again, cannot and will not meet unreasonable expectations. This view, I would argue, is one that has also been shared by his successors. with the current Foreign Minister, Senator Bob Carr, making clear on a number of occasions this year that there are limits as to what the Australian government can do to assist Australians overseas. Since Senator Carr assumed the role of Foreign Minister, he has already had to deal with a number of high-profile cases involving Australians abroad. These cases include Julian Assange, the Australian Wikileaks founder, who originally was on bail awaiting extradition from the United Kingdom to Sweden, but who has now sought and been granted asylum by Ecuador and is currently residing in the Ecuadorian Embassy in London. Melinda Taylor, an Australian official of the International Criminal Court, who was detained in Libya for 26 days in June-July by local officials following concerns over her conduct after interviewing Saif Gaddafi, who himself is the subject of an arrest warrant by the International Criminal Court. Alexandra Pippi Bean, an Australian aid worker who was detained for questioning in Libya for 7 days in late September in relation to her role as a witness in a Libyan police investigation. And more recently, Sarah Armstrong, an Australian lawyer working for the company South Gobi, a Rio Tinto subsidiary, who has been detained in Mongolia since mid-October in relation to ongoing anti-corruption investigations by the Mongolian Independent Authority Against Corruption. In addition to these contemporary matters from 2012, the Australian government has ongoing issues with respect to two members of the so-called Bali Nine, Andrew Chan and Myron Sukumaran, who remain on death row in Indonesia following their 2006 conviction of drug trafficking charges, and now the Perth man Dominic Bird, who following his arrest in March in Malaysia this year faces serious drug charges which could lead to the imposition of the death penalty upon conviction. All of these current and ongoing cases reflect not only the challenges faced by the Australian government in dealing with the situation of Australians overseas, but also the range of diplomatic and legal issues these cases pose for the government. These include the following. 1. What are the expectations of Australian citizens as to what the government should do on their behalf? 2. What the Australian government currently says it can do on behalf of its citizens. 3. The legal ability and capacity of the Australian government to respond and represent Australians abroad. And finally, the discretion that rests with the Australian government in making diplomatic and legal representations. In this lecture, I shall address all of those issues, plus make some particular observations regarding two of the most high-profile of the recent cases, that involving Stern Hu in his trial in China between 2009 and 2010, and Julian Assange. By way of conclusion, I wish to make some recommendations regarding how the Australian government should conduct itself when providing consular assistance and diplomatic protection. Can I at the outset make clear that I do not seek to contest the position that when Australians travel or live and work overseas, they are subject to the local laws of the country they are visiting or travelling within. As successive Australian foreign ministers have recently been at pains to emphasise, Australian law and legal standards do not follow Australians overseas. Nevertheless, when the application of those local laws is contrary to international law, especially international human rights law, the ability of the Australian government to intervene is considerable, irrespective of arguments about the need to respect foreign legal systems. So let me turn to my first point, and that is the expectations of Australian citizens as to what the government should do on their behalf. There seems to be a strong public perception that it is the Australian government's duty to protect Australians abroad. In a 2007 poll by the Lowy Institute, the public was asked about what they thought Australia's foreign policy goals should be. And amongst the number of responses, a total of 63% of respondents stated that it should be the protection of Australian citizens abroad. When asked whether it is the duty of the Australian government to provide assistance to Australians caught up in dangerous events in another country, an overwhelming 81% of respondents said yes. The poll then asked a follow-up question, which was, if they are citizens of another country as well as citizens of Australia, is it still the duty of the Australian government to help them? In other words, the case of dual citizens. In that case, 71% of the respondents still said yes, there is an obligation, as far as the respondents felt, on the part of the Australian government to provide these persons with assistance. This expectation on the part of citizens is matched, it would seem, by the ongoing demand for consular services. On the basis of Department of Foreign Affairs and Trade figures from annual reports, the number of consular cases rose by over 50% in the 5 years to 2009-2010, with over 200,000 cases annually, though it immediately needs to be acknowledged that many of those cases may be of a relatively minor matter involving basic levels of advice and assistance. Citizens have also become more critical of the Australian government when they believe it fails to provide assistance. For example, in September, the family of Pippi Bean was critical of Foreign Minister Carr for not, and I quote, picking up the phone to speak to his Libyan counterpart while Miss Bean was being held in Libya. Miss Bean subsequently told Fairfax Press that, and I quote, Australia was casting me out. Julian Assange, in particular, has been critical of what he has claimed has been the lack of assistance provided to him by the Australian government. Secondly then, what does the Australian government currently say it can do on behalf of its citizens? Over the past decade, especially with the development of the DFAT Smart Traveller website, the Department of Foreign Affairs and Trade has posted online not only an increasing array of advice for Australian overseas travellers, but has also sought to more clearly define the extent of its responsibility towards citizens. The current December 2011 iteration of that commitment can be found in a document called the Consular Services Charter. The Charter is described as outlining, and I quote, the high standard of service that our clients can expect from the Department of Foreign Affairs and Trade, DFAT, when seeking consular assistance. The Charter indicates that the capacity of DFAT to offer consular assistance is influenced by local laws and customs and international rules governing consular work. The role of DFAT is described as, amongst other things, to provide prompt, effective and courteous consular service, and I quote again, advising you of the services we can and cannot provide and the fees and charges that apply. The Charter then goes on to list 15 individual services that can be provided and 17 services that cannot be provided. Many of the identified areas where DFAT indicates that it can provide assistance are what may be considered fairly routine matters, including providing advice and support in the case of an accident, serious illness or death, assisting victims of serious crime, arranging a replacement passport, and providing notarial services which extend to witnessing documents. Of relevance for the current discussion is also the following statement, and I quote, assist if you are arrested overseas by visiting or contacting you and by arranging for your family to be informed if you give your consent. We also seek to ensure that you are treated fairly under the laws of the country in which you have been arrested. With respect to services that DFAT makes clear that it does not provide, the Charter lists, amongst others, the following: payment of medical services, provide translation services, and paying your hotel bill. The following, however, are of particular interest to my remarks this evening. DFAT indicates that it does not provide legal advice and get you out of prison or seek special treatment for you. So, having covered what the Australian government publicly says it can do to assist Australian citizens overseas, what is the legal ability and capacity of the government to represent Australians abroad? An important legal distinction needs to be made between consular assistance and diplomatic protection. The 1963 Vienna Convention on Consular Relations provides the basis in international law for a government to provide consular assistance to a citizen in another state when that citizen has become the subject of judicial or other related proceedings in that state. The Vienna Convention makes clear that an obligation exists in international law for the state of nationality to be advised following the arrest or detention of a national. And these obligations may be supplemented by bilateral arrangements which further extend the right of consular assistance. And indeed, Australia's bilateral consular agreement with China is a prominent example of such an agreement to that end. Under the Vienna Convention, an important right for the state of nationality is consular access, whereby a consular official is able to gain physical access to a national to check on their welfare and, where appropriate, provide assistance to them. Consular assistance is to be distinguished from diplomatic protection, which is where the state intervenes on behalf of its national when that national has suffered or may suffer an international wrong. In the case of citizens, serious violations of their international human rights are the most common basis for the exercise of diplomatic protection. Diplomatic protection has its foundation in the international law of state responsibility and is grounded in the legal fiction that an international wrong to a national is also a wrong against the state of nationality, who has the capacity to act in such a case to step in and represent the interests of the national against the state of wrongdoing. This is an action that can be undertaken at the diplomatic level or via international law, in which case litigation before an international court could be one possible outcome. So, having looked at the law of consular assistance and diplomatic protection, what about the discretion that exists with the Australian government in making diplomatic and legal representations? This is clearly one of the key issues that exists in terms of the extent of Australians' rights when it comes to their principles and their rights as a citizen being protected when they're abroad. And there's been some commentary on this by a number of government committees. So, for example, in 1997, the Senate Foreign Affairs, Defence and Trade Committee's report on Australia's government consular services, entitled Helping Australians Abroad, described consular protection as a state's right. Likewise, in a 2006 statement to the 6th Committee of the United Nations General Assembly concerning diplomatic protection, the Australian representative stressed that the exercise of diplomatic protection is a right rather than a duty of a state. Ultimately, these positions are also reflected in the work of the International Law Commission, which in 2006 concluded its work on diplomatic protection. The International Law Commission's draft article on diplomatic protection, with its accompanying commentaries, observed in draft Article 3 that, and I quote, "The state entitled to exercise diplomatic protection is the state of nationality." And then in Article 19 it goes on to refer to what is called recommended practice, where it includes that a state should, and I quote again, "give due consideration to the possibility of exercising diplomatic protection, especially when a significant injury has occurred." And then in the accompanying commentary to that article, the International Law Commission further observes, "A state has the right to exercise diplomatic protection on behalf of a national. It is under no obligation to do so. The internal law of a state may oblige a state to extend diplomatic protection to a national, but international law imposes no such obligation." And in a subsequent article written by the rapporteur of the International Law Commission, Professor John Dugard, Professor Dugard said, "A state will make a political decision whether to exercise its discretionary power in favour of diplomatic protection." So in summary then, the current state of international law quite clearly indicates that there is a discretion on the part of a state, not an obligation on the part of a state, to exercise diplomatic protection. Nevertheless, the International Law Commission concedes that if the internal law of a state obliges a state to exercise or extend diplomatic protection, well then it will be so bound under its domestic or national law. For my 2005 experience in providing advice to the legal team representing the Australian man Van Thuong Nguyen, who was on death row in Singapore, the Howard government certainly exercised the discretion as to whether it would formally exercise diplomatic protection by way of commencing a claim against Singapore in the International Court of Justice in that manner. Nevertheless, in my dealings at that time with Australian government lawyers and also Foreign Minister Downer, I remained impressed by their willingness to consider international legal options to halt Van Nguyen's execution. And whilst ultimately the Australian government elected not to pursue action in the International Court of Justice, my point is that there was a genuine consideration of that particular option by the Australian government at that point in time in 2005. So I've now addressed the four preliminary points that I wanted to consider, and I'll now move on to look at some particular cases. And the first case I wanted to assess was that of Stern Hu. Stern Hu's case is, of course, one concerning an Australian Rio Tinto executive of Chinese ethnicity. Stern Hu was arrested in July 2009 on unspecified charges in relation to his business dealings on behalf of Rio Tinto in China. The arrest triggered the provisions of the 1999 Agreement on Consular Relations between Australia and China. The agreement, as I've noted before, supplements the 1963 Vienna Convention on Consular Relations, but in the words of DFAT, not only confirms and amplifies the convention, but also, and I quote, expands its provisions in some respects. And in this respect, the DFAT National Interest Analysis that was prepared for the Joint Standing Committee on Treaties noted, and I quote, the Australian government has encountered particular difficulties in securing consular access to arrested or detained Australian citizens who also possess Chinese citizenship. This is because China's nationality law does not recognise dual or plural nationality. The agreement reaffirms that an Australian citizen who enters China on an Australian passport is entitled to consular access and assistance from Australian consular posts, end quote. Consistent with the provisions of the 1999 agreement, Australian consular officials were advised of Stern Hu's arrest in July 2009 and were given access to him on 10 July 2009. Up until the commencement of Hu's trial in March 2010, no irregularities apparently arose under the agreement, and at all times Australian consular officials were granted appropriate access to Stern Hu. However, in the case of Stern Hu's trial, a significant issue arose 1 week before it commenced, when Chinese officials informed Australian diplomats that they would only be able to attend part of the trial, with the effect that a portion of the trial would be held in secret. This immediately raised issues as to the interpretation of Article 11 of the 1999 Consular Agreement, which provides that, and I quote, a consular official shall be permitted to attend the trial or other legal proceedings. The significance of these access rights Australian consular officials were entitled to enjoy during a trial of an Australian citizen in China had in fact been the subject of particular comment by the Joint Standing Committee on Treaties when it considered the consular agreement in 1999. At that time, the committee observed, and I quote, the proposed agreement guarantees consular representation at trial. It would seem, therefore, that the Australian government had every expectation when the consular agreement was concluded that Australian consular officials would be entitled to attend the trial of Australian nationals in China. On 18 March 2010, 4 days prior to the commencement of the trial, the then Foreign Affairs Minister Stephen Smith indicated that he was disappointed with the Chinese decision to close the court for the purposes of the second charge against Stern Hu, and that Australia had asked China for the matter to be reconsidered. Australia was subsequently advised by China that it would not vary its position with respect to consular access to the trial, with the effect that Australian consular officials were able to attend the first bribery phase of the trial held on 22 and 23 March 2010. However, once the trial moved to the obtaining commercial secrets phase of the proceedings late on 23 March, Australian consular officials were required to leave after which the proceedings continued behind closed doors. From a treaty law perspective, the Chinese interpretation of the consular agreement in this instance does not conform to the ordinary and clear meaning of the treaty, which in Article 11 makes clear that consular officials shall be permitted to attend a trial. While there is a recognition in Article 11, paragraph 2, of the rights of the receiving state, in this case China, with respect to how the trial is to be conducted, so that full faith is accorded to the laws and regulations that apply to Chinese courts, it is also made clear that such laws, and I quote, must enable full effect to be given to the purposes for which the rights accorded under this article are intended, end quote. It would seem, therefore, that in this instance, Australia had a very solid legal argument to make that its consular officials should not have been excluded from any part of the trial, a view that was effectively confirmed by Foreign Minister Stephen Smith in his press conference on 29 March, which was the day of Sternhu's verdict. In this instance, Australia effectively permitted Chinese law and a Chinese interpretation of the consular agreement to override the clear words of the treaty, with the effect that the partial trial of an Australian citizen was conducted behind closed doors. Not only does this call into doubt the consistency of the conduct of the trial with international human rights standards, but it also highlights the vulnerability of Australian citizens subject to a foreign trial when the Australian government chooses not to pursue its treaty rights, which had been expressly negotiated to permit observations of Australians subject to trial in China. The plight of the Australian businessman Matthew Ng, detained by Chinese police in November 2010, brought to trial in August 2011, and then convicted and sentenced to 14 and a half years in jail in December 2011, also raises concerns over the conduct of trials in the Chinese legal system. While consular access was granted in that case, including to the trial, media access was denied, notwithstanding assurances that were given to the Australian government of an open trial. The Sternhu and Matthew Ng case bear striking similarities. Both involve Chinese-born business executives who relocated to Australia and gained Australian citizenship before returning to China and developing a high business profile before running afoul of local authorities and being caught up in the Chinese legal system. Another recent case concerning an Australian businesswoman of Chinese ethnicity, Charlotte Chu, also raises similar concerns. Now, in May of this year, Senator Carr raised these three consular cases with the Chinese government, where he was advised by the Chinese Foreign Minister that China did not, and I quote, recognise dual nationality, end quote. And at that time, Australia's ambassador to China indicated that, and I quote, where Chinese citizens have renounced their Chinese nationality and have entered China on Australian passports, we can gain access to them under our bilateral consular agreement. So in conclusion on this point, the cases of ethnic Chinese Australians doing business in China seems to me to highlight some of the particular challenges that Australia may face in the Asian century, in which China is becoming the focal point for regional and global business. Now I'll make some remarks concerning Mr. Julian Assange. The ongoing legal tussle over the Wikileaks founder and Australian citizen Julian Assange is nearing its second anniversary, yet there appears to be no immediate prospect for a speedy resolution of his situation. Assange is currently residing in the Ecuadorian embassy in London following Ecuador's decision on 16 August this year to grant him diplomatic/political asylum. Assange claims that he remains in fear of being eventually extradited to the United States to face various charges associated with the publication by Wikileaks of US diplomatic cables. There has been speculation that Assange may be subject to charges of espionage in the United States, which could carry the death penalty upon conviction. However, to date, there is nothing on the public record to suggest that the United States has commenced legal proceedings against Assange, and his extradition to the United States has not been sought. Indeed, the US Ambassador to Australia, Jeffrey Bleich, has publicly stated that the United States is not seeking Assange's extradition. Now, of course, the background to all of this is that Assange originally became embroiled in a series of legal proceedings when the Swedish Prosecution Authority sought his extradition via a European arrest warrant on 2 December 2010, at a time when Assange was a UK resident. The warrant was issued not in relation to charges formally brought against Assange, but in relation to his further questioning in relation to matters that were alleged to have taken place in Stockholm in August 2010. The accusations related to sexual molestation in one case and the other related to rape. Following the issue of the European arrest warrant, Assange was taken into custody in London, but was soon released under strict conditions. This was followed by a series of appeals against extradition, and ultimately, on 30 May this year, the UK Supreme Court dismissed Assange's final appeal. This matter, of course, took a spectacular turn on 19 June when Assange walked into the Ecuadorian embassy in London and sought diplomatic asylum. Eventually, after 2 months of deliberation, on 16 August, Ecuador announced that Assange would be granted diplomatic asylum. However, this has not been the end of the matter, as the United Kingdom has indicated that it does not recognise Ecuador's granting of asylum. The result is that if Assange were to leave the protection of the Ecuadorian embassy, he is liable to arrest and extradition to Sweden. The London Metropolitan Police remain outside the Ecuadorian embassy in London, ready to arrest Assange if he were to leave. And I'm happy to report that on fieldwork for this lecture 3 weeks ago, I can confirm that the bobbies are located on the doorsteps of the Ecuadorian embassy in London, ready to nab Mr Assange at any point in time. Now, provided Assange remains in the Ecuadorian embassy, he enjoys certain protections under international law. The 1961 Vienna Convention on Diplomatic Relations provides under Article 22 that diplomatic premises such as an embassy are inviolable. As such, the embassy cannot be entered by the British authorities, including the Metropolitan Police, without consent. As the Assange matter reached a pivotal point in mid-August, Ecuador revealed that Britain had threatened to rely upon its Diplomatic and Consular Premises Act and revoke the Ecuadorian embassy's diplomatic protection so as to enter and seize Assange. This threat was extraordinary and without modern precedents, and it was unsurprising that the Ecuadorian government responded with such fury to Britain's threat. That Britain made such a threat shows how seriously the Assange affair is being considered and its potential to have broader ramifications for international relations. British Foreign Secretary William Hague has now downplayed any suggestion that the Ecuadorian embassy would be raided and emphasised that Britain will act consistently with international law. Nevertheless, Hague and the British government have made it clear that they have a legal obligation to Sweden to extradite Assange and that they will continue to seek his arrest for breach of his bail conditions. What then are the legal options, or indeed diplomatic options, that might be open to Australia with respect to Julian Assange? First, Australia can clearly continue to support Assange and provide him with consular assistance, and where appropriate seek consular access to check on his welfare. However, while he remains under the protection of Ecuador, it would appear he needs very little such assistance for the time being. Ecuador has recently expressed some concern over Assange's health and raised questions as to what would occur if he requires medical treatment outside of the embassy. However, at present, that appears to be a hypothetical question. Secondly, and perhaps more substantively, Australia does have the capacity to seek diplomatic assurances from Sweden that if Assange is extradited to Sweden, that he will be subject to due process under Swedish law, that any trial would be conducted consistently with international human rights norms, and that Australia would enjoy full consular access to Assange during that time. Thirdly, Australia could seek an assurance from Sweden that following the completion of all Swedish legal proceedings against Assange, which formed the basis for his extradition from the UK, that he would be deported to Australia. This final assurance would seek to directly address Assange's concern that once in Sweden, he would face onward extradition to the United States. So I now move to my concluding remarks. The Australian government has a range of responsibilities towards citizens who face peril overseas. In some instances, consular access and support may be all that is required. In other cases, especially following natural disasters or terrorist acts, greater levels of support are justified. The government is clearly capable of providing first-class support. Assistance for Australians following the 2002 Bali bombings and the 2004 Boxing Day tsunami are examples. When citizens are being held overseas in circumstances where their human rights are being violated, the government has a particular moral responsibility to act. Senator Carr's active diplomacy in June to secure the release of Melinda Taylor in Libya is illustrative of the Australian government's capacity in these cases. Nevertheless, Australians are sometimes critical of the government response, often expressing the view that they have either been poorly advised or in some cases received no support at all. The most prominent of these cases was that of David Hicks, who in 2007 commenced legal action against the federal government, seeking an order that the Australian government exercise its executive discretion and seek his release and repatriation from Guantanamo Bay, where he had been held since early 2002 without charge. While ultimately the substantive aspects of that case never reached trial, the preliminary finding of Justice Tamberlin in the federal court was suggestive of a duty on the part of the Australian government to provide Mr Hicks with protection. Parallel cases involving Guantanamo detainees in Canada and the United Kingdom also grappled with this question. And in a 2004 Canadian decision concerning Omar Khadr, a Canadian judge referred to, and I quote, the legitimate and reasonable expectation of a Canadian citizen detained abroad. What the Australian experience suggests is that there are no clear legal entitlements of Australian citizens to receive consular assistance and ultimately diplomatic protection from their government. While the DFAT Consular Services Charter is an important statement as to how the government will respond to an Australian in need of assistance, it avoids any legal undertaking to provide that assistance. Here a contrast can be drawn between Australia and the United States. The US State Department asserts that it and I quote, our embassies and consulates abroad have no greater responsibility than the protection of US citizens overseas, end quote. The Secretary of State has, and I quote again, responsibility to provide consular protection and services to citizens abroad, end quote. Now, the United States' position in this regard is not unique. Countries as diverse as Brazil, Kazakhstan, Hungary, China, Estonia and Germany recognise various forms of legal obligation to protecting the interests of their citizens in foreign states. In 2009, then Prime Minister Kevin Rudd made the following statement to Neil Mitchell in relation to the Stern Hu matter. Mr Rudd said, "Our objectives, of course, are to support Mr Hu in these circumstances as we would any other Australian citizen. That's the responsibility of all Australian governments," end quote. However, my argument tonight is that the responsibility that Mr Rudd referred to is not currently legally recognised. In light of Australia's recent experience in protecting Australians overseas, I therefore offer the following suggestions. First, that Australia needs to adopt a firmer position regarding the rights of naturalised Australians who have returned to their country of birth to work. The Stern Hu case highlighted the difficulties that can be faced with ethnic Chinese Australian citizens and adequately providing them with consular assistance and protection in China. Australia needs to resolve any ambiguities regarding the status of these citizens and ensure that the Hu case has not set a precedent. Secondly, the Australian government could seek to frame some of its consular and diplomatic representations around the rights of Australian citizens under international human rights law. Core international human rights standards are binding upon all states and apply within those states to both nationals and foreigners. By advancing the rights of Australians consistently with international human rights law, the Australian government would provide a robust legal framework for consular officials and diplomats representing Australians overseas. Finally, the time has come for, at a minimum, the right of consular assistance to be enshrined in Australian law so that governments have a standard which they are required to meet in providing assistance to Australians overseas and in the most egregious of cases can be held accountable. A Consular Services Act should be enacted which would build upon the DFAT Consular Services Charter to not only make clear the capacity of the Australian government to represent Australians overseas but also the legal entitlement of citizens to that representation. Such an act would assist in clarifying the extent of the legitimate expectations citizens have to assistance and representation, and would also go some way to resolving what appear on their face to be inconsistencies in the way in which the Australian government deals with some consular cases, and to ultimately ensure that cases such as that of David Hicks will never again be repeated. Thank you.
Well, thank you, Don. Good evening, everyone. My name's Stephen Bottomley. I'm the head of school in the ANU College of Law, and it'll be my pleasure in a moment to formally thank Don for his lecture, but we have some time for Q&A, and so I get a bit of a chance now to impersonate Tony Jones and to throw it to the audience. There is a roving mic, so Don, I might bring you back to the podium, and I'll field questions.
Thank you. Gerard Uiteragen, I'm the Deputy Head of Mission Charge of Consular Affairs at the Embassy of Belgium. So my experience shows that consular cases are totally different from one case to another. And I would say that I'm very afraid to give a legal frame to intervention in the sense that it might also work against a possible client or a possible cry for help from a citizen. Giving a legal frame gives you, of course, a nice conduct guidance to do and to present to your partner in the host country. But as I say, it could also be a barrier to some sort of intervention that you would need to do. Thank you.
We'll take that as a comment.
Your recommendation was for a statutory requirement or a statutory obligation of consular assistance. Would that not conflict with any political aims that DFAT might have overseas? And wouldn't a statutory obligation to do something also conflict, well, do you see what I mean? Maybe conflict with any political aims that they might have. So essentially force diplomats to do something that they might not want to do.
Look, thanks for that question, and ultimately that comes down to how my proposed Consular Services Act would be drafted. I think that on the basis of the interpretation of international law and the Australian government's position as it's been formally put in various international fora, the government would seek to retain some level of discretion, and I wouldn't contest that because, as the first questioner noted, each case is different, raising a range of issues. But I guess the key point in terms of proposing a Consular Services Act is to at least guarantee that Australians will receive a minimum level of assistance. And I think that will be helpful because at one level there are widely varying expectations on the part of the government, and at times it could be said quite varying practices on the part of the government to cases that sometimes appear quite similar. And on the other hand, the expectations of citizens are also quite widely varying. The Consular Services Charter, I think, is a good document in terms of outlining the extent of the services that DFAT provides, but ultimately I think this goes to a question as to what rights and entitlements citizens have. Citizens carry an Australian passport when they go overseas. They are actually subject, in limited circumstances, to Australian law while they are overseas. Citizenship relates to your allegiance to your country. And yet, at the moment, the Consular Services Charter, and as I've tried to indicate, Australian law, does not indicate any firm legal obligation on the part of the Australian government to its citizens. So that's why I'm making this proposal for deliberation.
When you say that China does not recognize dual citizenship, does that mean that they do not recognize someone becoming an Australian? They still consider their former citizens of China?
My understanding in terms of the Chinese position is that if a dual Australian-Canadian citizen was in China, that would not necessarily raise an issue in terms of any form of consular assistance or ultimately diplomatic protection for that individual. The relevant cases are ones in which we have dual Australian-Chinese citizens, such as the ones that I've referred to this evening, and the clear indication that's been given to the Australian government is that unless that Chinese national has effectively sought to revoke their Chinese citizenship and upon returning to China has entered China using an Australian passport, will then only under those circumstances will the Australian government's right and the right of Australian consular officials to represent that Australian citizen consistent with the provisions of the Consular Services Agreement between Australia and China be recognised. So the ambiguity and the issues that have arisen, as I understand it, are in relation to effectively dual Australian-Chinese nationals.
Australia does not require someone to renounce their citizenship since they accept dual citizenship. So in that case, a Chinese would not have renounced their Chinese citizenship.
Yeah, well, look, obviously these are matters that need to be subject to individual determination by persons who seek to return to China and quite legitimately engage in a range of activities there. But the issue has arisen, as I've said, in the context of persons who may still be carrying two passports, may have entered China with a Chinese passport, notwithstanding the fact that they also have an Australian passport. And that's where, as I understand from the cases that Senator Carr raised earlier this year in China, that complication has arisen. Now, it should be said that this issue is not an extraordinary one and that there are similar types of situations that exist, in my understanding, for dual citizens in various other places around the world. So the Chinese case is not an extraordinary one, but it's just one that has raised some particular issues for Australia.
I was interested in your proposal for a Consular Services Act and your suggestion that the Australian government ought to retain a discretion to exercise any duties under that Act, and I think that's undoubtedly correct. But I was wondering whether there might be difficulties in judging when that discretion's been exercised appropriately, when a lot of the evidence in relation to political matters is likely to be kept secret and confidential. I wonder how that would work.
Well, the most obvious example of where such an act would have been relevant would have been in the case of Julian Assange, I would argue. And indeed, the examples of where such acts have been adopted by a number of countries provides recourse in the most egregious of circumstances where citizens haven't received any appropriate levels of support given their circumstances. But look, there are many examples of law where a discretion will ultimately exist with a government. But this proposal really goes to a question of accountability and minimum levels of assistance that would be provided. Ultimately, in terms of whether a government would elect in extraordinary cases to actually exercise diplomatic protection on behalf of a citizen who might be facing execution. In those extraordinary cases, that clearly comes down, it seems to me, to a political judgment. But I think that such legislation could be drafted, and indeed, it should be noted that in the final years of the Australian Democrats in the Australian Senate, they actually drafted a bill particularly directed to the circumstances associated with Mr. Hicks and his plight. That bill was introduced into the Parliament in 2006 or early 2007, so there has been some preliminary thinking done already as to how such legislation could be framed.
I was wondering if you could speak just briefly on how much political momentum or traction this concept has got in terms of turning the Charter into an Act, and if there is sort of some traction already that you've noted in the Parliament, what sort of timeline you'd say in terms of it actually being turned into an Act?
Yeah. Look, thanks for that question. It's got no traction at all. I've decided to put it forward for consideration this evening.
Professor Rothwell, I'm interested in hearing your views on actually, we've often blamed the government for not providing services, but we actually never blame Australian citizens for not taking their brains with them when travelling. Perhaps your legislative framework should include obligations of the citizens while overseas to actually respect the laws of foreign lands and spelling out clear obligations which they perhaps would have. In my experience, a lot of people don't even know that they're going to Indonesia when they're visiting Bali. So it's unreasonable. I actually would like to argue that I blame Australian government for setting this kind of expectation for consular services, because when you ring up passport line, or immigration department, on their hold music, they have all these benefits of becoming an Australian citizen, including access to every consular assistance. Perhaps it's the marketing people that should work on this, but I believe that there should be, people should be held accountable for their actions and not expect SES troops to come in and get them out of every single situation, including the Prime Minister making a phone call when a delinquent teenager takes drugs in Bali and tells them everything will be fine, we're going to come and get you. So my question is, would you my question is, would you support would you support some level of obligations being spelt out in your framework as to what are the obligations of the citizens going abroad?
Look, thanks for your question, and I understand the premise of your question in many respects. I guess the way I would answer this is that, as I said in answer to a further question, it comes down to our understanding of citizenship. It comes down to the rights and responsibilities that Australians have as citizens. Australian citizens have responsibilities to obey Australian law. They're not necessarily bound to obey foreign law. And I think that is an important point of distinction. And I think even you would concede that some foreign laws are ones that Australians would find repugnant. Nevertheless, Australians are bound by foreign law when they visit foreign countries, and I don't in any way contest that. But my suggestions this evening go to the way in which Australia needs to think about the rights of citizens. We have had a long-standing debate in this country about human rights in a range of contexts, and this is just one particular component of it. And I don't disagree with you that the level of expectations that have been set in certain cases, just in the last few months and perhaps over the last year or so, one case that you particularly referred to, exceed, in my view, what is a reasonable expectation on the part of citizens. And governments need to not respond to media pressure, which I think often is what is occurring in some of these instances, and make quite clear that there are limits to what the Australian government can do. And I said in my opening remarks that Mr Downer went to some level to express that. So my suggestion of a Consular Services Act, as I said in answer to another question, was actually to generate some debate about this issue, to understand that there are rights that Australian citizens have, that there are responsibilities on the part of the government, but that this can also provide an opportunity for the government to further promote the Consular Services Charter. And I've looked extensively at that documentation on the DFAT website in preparation for tonight's lecture. There's some really strong material there. It would be interesting to know from DFAT how many hits that site gets in terms of Australians viewing that material prior to going overseas.
Well, the time is upon us, and our microphone carrier has done a full circuit now, so I'll relieve you of any further running around. Don, one of the measures I think of a good public lecture and a provocative public lecture is the range and number of questions that it engenders, and we certainly had that, and there'll be further opportunity after the formal proceedings to continue that. But on behalf of all of us here tonight, Don, I would like to thank you for your contribution to this really important public discussion about issues of consular and diplomatic protection, the rights and indeed obligations of Australian citizens overboard and overseas, rather, and the legal questions associated with this. That's a separate issue. That gets to your expertise in the law of the sea. Don, once more you've added greatly to the quality of public policy discussion in Australia and, more importantly, in Canberra, and we're grateful to you for that and for your very careful analysis of this very delicate intersection between legal, political and public perception issues. So on behalf of all of you, I'd like to pass on thank you and ask you to join me in another round of applause for Don. Ladies and gentlemen, refreshments are being served in the Coombs extension, which you can access by leaving through the rear of the theatre. I thank you for your attendance here tonight, and I hope you will participate in future public lectures. Thank you again.